And hope everybody has wonderful Saturday so far, around noontime now, and wishing you guys all have a great Easter tomorrow. Yesterday was a Good Friday. I spent most of the time in the mediation in downtown LA, so I wasn't in the office. So when I came back, the first thing I got is this stack of documents, but that's attorney's life. Not complaining. I'm just showing that I'm not gonna do that till next Monday. I'm just gonna stay in the office, do some catch up, and read newspaper. Interestingly, I read the newspaper today, the Daily Journal for Los Angeles. That's kind of like a publication for attorneys. I read an article about fee requests slash for attorneys who sued Volkswagen. And the Volkswagen got in trouble a few years back about manipulating the emission data, especially in California. I don't know if it's nationwide, but especially in California, and got found out, and there was a class action filed against Volkswagen. Now, the class action attorneys in this case already received about 175 million in attorney's fee. They requested another 28 million, but the court only approved 3 million of it. Okay. Now that leads to today's question: is it beneficial to have attorney's fee clause in a contract? Now there's only two major ways you can get attorney's back. I think all across the United States, and especially in California, everybody's paid their own attorney's fee. All litigants, they have to do that. Unless, one, you guys have a attorney's fee clause in a contract, specifically state that a prevailing party will recover the reasonable attorney's fee and the cost. Or if there's a statute stating the prevailing party will recover the attorney's fee and cost, those are typically in discrimination cases, employment cases, civil rights cases, and some other cases that the statute particularly stating that prevailing party is able to recover attorney's fee. In the business cases, we all look in a contract, okay? Whether or not there's an attorney's fee clause, if there is, potentially you can recover attorney's fee. If not, everybody pays their own. The reason I say potentially, because at the end of the case, when you win the lawsuit, go out to the trial, you win, or even before the trial, when the case got dismissed by merit, then we file a motion for attorney's fee when we ask the court to approve it. Generally, the fee is mandatory according to the law, meaning as long as you have a contract and as long as the contract provision provide the reimbursement of attorney's fee to prevailing party, the court will generally do so. Okay, but amount as to the request is discretionary to the court. So the judge will go into, when we file these motions, we will attach our invoices. The court will review the charges, the hours spent, whether or not they are reasonable, whether or not you are efficient, depends on what type of the cases, whether or not the cases are complicated or a simple one. Okay, so the judge will make the determination as to the amount. That's discretionary. And generally speaking, let's say if we request $100,000 in attorney's fee, and that's what a client actually paid the firm. Sometimes we got full amount back. Sometimes the judge say, you know what, I only want to grant you $80,000. Okay. My experience is generally judges are very careful granting the attorney's fee and very suspicious of attorneys submitting the invoices. So they do go over each entry and make that determination. So if you spend $100,000 in attorney's fee, you may not get $100,000 back because it's discretionary to the court. Okay, that's one thing. And the other thing is a double-edged sword, and that's where we need to consider very carefully. It's double-edged sword. Yes, you can get an attorney's fee back if you win a case, but in the event you lost the trial, then you gotta pay your own attorney's fee plus the other side's attorney fee. So it's a double-edged sword. Generally, I advise client about pros and cons. When I'm drafting a contract, I advise client pros and cons for having attorney's fee clause in the agreement. Okay, 60% of the time I'm leaning towards no, because if you have attorney's fee clause in it, okay, this is my opinion and my strategy. Okay, when I advise client and based on my experience, most of the time, when you have attorney's fee clause in it, the other side's attorney, because we have no control of what attorney they're going to hire. Okay, if they hire a good one, they find out whether or not the case is a merit or not, and they will take a case based on that and advise the client appropriately. If they happen to find an attorney that they'll say, hey, I'll represent you. You don't have to put money up front. We'll get the attorney's fee back at the end. Well, potentially, the case, that attorney can make a mountain out of anthill, on the case, even though it's a very simple one. Okay, potentially, and I've seen it. They can also use that as a leverage for settlement, because client is exposed to certain risks for additional attorney's fee, obviously. So that's a leverage they can use to negotiate a settlement. So because of those two situations that I have seen, generally I advise client not to put there. But there are times that depends on client. Some client they feel that they want to have that clause in it just in case later on. So if you have particular situation or you are in a situation want to draft a contract, consider whether or not the attorney's fee clause is appropriate for your situation. Always consult with your local attorney. Make sure that you guys talk through what's good, what's bad. I can just only tell you my opinion and provide general information. And obviously, your situation are unique. Always consult with your attorney in that regard. So that's the interesting thing I found out today in the Los Angeles Daily Journal, and hopefully you guys pick up something from this video, and wishing you have a good Easter tomorrow. Bye.